Same-sex marriage was not a part of the medieval culture. The same-sex union, however, could be accomplished by means of collateral adoption instead of gay marriage, which was recognized in some medieval jurisdictions. This concept of collateral adoption was derived from the Roman period, when an adult with no heirs could formally adopt an adult to formalize a closer relationship between two men, and was seen as a ceremony that entitled the men to legally call each other brothers. While their custom was different from the concept of marriage as it was understood under medieval law, it was nonetheless analogous that it was a ceremony that established property rights. The issues that the court had to decide was the extent that property was affected by the agreement between two individuals of the same gender, and whether the agreement impaired the property rights of the children or spouses of the two individuals in the agreement. The general approach to a formal agreement between two individuals of the same gender was to assume that it was a business agreement similar to a partnership. As a result, the union would not generally affect any pre-existing property rights of children or spouses. The issues that the court had to decide was the extent that property was affected by the agreement between two individuals of the same gender, and whether the agreement impaired the property rights of the children or spouses of the two individuals. Medieval canon law, however, did not formally recognize the concept of collateral adoption as a substitute for marriage, despite evidence that it was informally practiced. This indicates that the courts were not willing to become directly involved in these types of personal matters as long as the property rights were not affected by the arrangement made by two friends of the same gender.